a man in custody begs for treatment, while his lawyer fights for day-for-day jail credit, only to have prosecutors reveal he's been calling his alleged victim from jail just days ago. This is a motion for furlough in a 2026 pretrial case where addiction recovery collides with alleged witness tampering and outstanding warrants.
Of Desmond Timantois. This is our motion for furlough. He actually has a bed date for tomorrow. I did also, depending on the court's ruling, I did send in a speedy trial waiver in case we need that to allow him to go and do that furlough because we are still in pretrial. There was alcohol related in the allegations of the pending charges. And so, this is reasonably related to the charges to have him go to treatment. And I am also asking for day-for-day credit. I'm not sure if this court does that when we get back or in advance, but that's part of the request as well. And Northwest Resources will be giving him a ride there and back.
What time?
It's in the letter that I attached, I believe.
And Mr. City's position?
The city would object to the furlough request. There have been violations of the no contact order from the jail. There's currently a police report that's been filed with OPD that the defendant continues to contact the victim via jail phone calls. If he's released to furlough, we're not going to be able to monitor those attempts at communicating with the victim, and he's going to be able to continue to violate that order. Further, it's my understanding this court does not give day-for-day credit, and that the furlough is just essentially a halt in the incarceration count.
Has he been sentenced?
No,
Your Honor, this is pretrial. And Your Honor, answer to the question was 8 a.m.
No,
they were going to pick him up at 8 a.m.
Okay. The one case is post-disposition, the case ending in 261. On those no contact order allegations, has she been picking up? Is this something that this is unwanted contact, or this is going on and he shouldn't be doing it? I'm not saying that or
it's uninvited. It's uninvited contact, and a police report has been filed.
Got it. Are they going to have new charges?
I believe they're investigating jurisdiction.
I see. When was the most recent allegation?
Just one moment. Let me confirm, because I have a note here from the 20th, and I want to confirm that was the date it happened versus when it was reported to our office.
As in 6 days ago?
And we have a subsequent. It is the 21st.
Give me a minute. What cause number did you file the letter under, Ms. Lamar?
Here's why this request failed. Furloughs are discretionary releases that pause jail time so defendants can attend treatment, but judges weigh public safety heavily. The Sixth Amendment guarantees counsel at all critical stages, which is why the judge appointed an attorney before any further hearings, but it doesn't guarantee freedom. Fresh allegations of witness contact, combined with 2-year-old DUI warrants, gave the court too many reasons to say no.
2026-179.
Can the transportation there, and he's got warrants there. How long have those warrants been out? I'm kind of concerned by those there, Ms. Lamari. What do you know? What, if anything, do you know about those?
Your Honor, I do not. I'm sorry. The tribe had specifically reached out, to him, and then, and so I just wanted to make sure he had the opportunity to request it. Spoken to him about the warrants, though. That's the answer.
Give me a minute. So look in the Lincoln County case, it looks like he was released, a warrant was issued, and released with scram. And that warrant's been out since 2022. So there's a couple things, Ms. Lamari. First of all, Mr. Carver's right. We typically don't do day-for-day credit on this. That's just generally the policy of the court. At this time, I'm going to deny your request. I think there's just a few too many red flags here in terms of the allegations of violations of no contact order, which are just allegations. Nothing's been proven beyond a reasonable doubt. Combined with the lengthy warrant times on DUIs, which is, and the bail in this case is fairly substantial. So at this time, you can find out more information on those warrants, maybe get those addressed, combined with some sustained period of compliance with the no contact order. we can take another look at it. But for today, we're just going to leave future court dates set. He's got a confirmation on April 9th. We'll leave that set. And I think that's April 9th. And I'll deny it, but again, would be without prejudice. You can bring this back if additional information comes to light. But again, there's just too much, generally I grant these, even over the city's or the prosecutor's objection, but I think there's a little bit too much going on here right now, both in the past and currently. We have an allegations, real recent of, alleged violation. So that's what I'm going to do here for today.
Thank you, Your Honor.
You can be taken back, Mr. Timontois. What's your name?
Justice Crofton.
Give me a minute there, Mr. Crofton. This kind of came to me at the last minute.
Yes, sir.
So you're here on, you're supposed to be here in March. A warrant was issued and you're picked up on the warrant. So you need to be arraigned, and then we need to set conditions of release, and then we need to talk about court-appointed counsel. So Ms. Dutch, did you get a chance to speak with him regarding his legal rights?
I did not, Your Honor. He was not on the calendar. So
Can put you into a breakout room.
thank you.
And can you put him into a breakout room? Yeah, you'll go into a breakout room. You can discuss with all that with him. And probable cause was previously established. You don't need to worry about that.
Oh, all right.
So Ms. Dutch, you get a chance to speak with Mr. Crofton?
I did, Your Honor. Thank you.
And then
I did discuss his legal rights, so we can waive further arraignment at this time. The court indicated the probable cause was plea of not guilty and request a court-appointed attorney. It looks like Mr. Crofton was previously represented by Sound Defenders, which has Wednesday calendars, and he continues to.
So Mr. Crofton, you're charged with one count of theft. That's a gross misdemeanor, which carries with it a maximum penalty of 364 days in jail and a $5,000 fine. A plea of not guilty will be entered. This matter will get set for future hearing. We're going to set conditions of release. I'm going to hear from the city, and then after that, I'll hear from Ms. Dutch. And I will appoint public defense to represent you. And so, Ms. Pinkston.
Thank you, Your Honor. Mr. Crofton has a lengthy criminal history. A lot of that is theft. You'll see that all of his recent crimes are mostly theft related. You'll also see that he's had most of his criminal history has warrant activity with almost every case that he's had in the system. He has an active warrant for a theft from 2021, and that's out of Centralia Muni. I think the warrant that was issued on this matter was for $10,000, and that's for a theft, and that speaks to his history and his likelihood to reoffend and also not to reappear. It's just kind of a constant circle that we go around Mr. Crofton. So at this point, I do think that bail is appropriate. I'm going to ask for $5,000, even though the booking bail was $10,000. So $5,000, no contact with Home Depot, no law violations, and appear at all court hearings.
Ms. Dutch.
I do acknowledge Mr. Crofton's history, but I would ask the court to consider the presumption of release and the nature of this charge being nonviolent. Mr. Crofton doesn't have much in the way of contact information, but he indicated he can use his mother's phone number. He can provide that to the court after his release. He couldn't remember it at this time. But she is a peer counselor and works with the women's program at the Union Gospel Mission. So he does have that support. So he's asking the court for release.
And is there a no contact provision, Ms. Pinkston?
No contact with Home Depot.
So this is the theft, gross misdemeanor theft. But again, just looking at, there's warrants in every case. And even in this case, I mean, I guess I just don't have a whole lot of confidence in your ability to reappear for court.
Poor mister. I didn't kind of honor. Is it all right if I speak?
I don't want you to talk about any of the facts of the case.
Ms. Dutch, I don't want you to talk about the facts of the case. The only thing we're talking about now is conditions of release. My position on setting bail is based on your, you have a really difficult time to come court, and be completely frank with you, we couldn't even get you to come to. up there in custody.
I will
And so
come
I
to
don't,
court, Miss Your Honor. I will come to court. I promise you I will. I've been under a drug influence. I've been really bad with that. And this last 5 days here, I've been able to kick my drug addiction. Whatever it's called, detox from my. It's really hard when you're doing that. And you're like, I don't want to be sick, and you want to be able to like move forward and do that, and you go and you do stuff like thefts and stuff. But being here and kicking my drugs like that, and being able to like think and see and stuff, because my mom's got an apartment for me downtown that I can just have for myself, pretty much. Me and my little brother, as long as I'm not on drugs, and this is all that I've been needing to be doing, and I'm like really excited. If you're on me right now, that's what I'm gonna do. I'm gonna get out and go, most likely, maybe talk to my mom. I mean, I don't know if I'll talk to her right now tonight, but I'm excited because I'm not on the drugs, right now.
that's a week.
I'm not addicted to fentanyl is what I'm always having to do. I always have to like carry that with me. I'm like, crap, I gotta go get my another fucking set of drugs.
So I appreciate all that, Mr. Crofton. I am going to set bail in the amount requested by the city, 5,000 cash or bond. If that's posted, don't have any criminal law violations, stay out of the Home Depot. We're going to set a court date a week from today. So that's pretty short. If you meet with an attorney, you get a plan in place for some sort of thing, we can take and we'll go from there. And so maybe you can get out fairly quickly, but this is how we're going to start based on, what I see about, both in the past as well as since you've been up there. So that's what we're going to do here for today. And you can be taken back.
Thank you.
Your Honor, did we get a court date?
Yeah, a week from today, April 2nd at 1:30.
Since Sound Defenders is most familiar with Mr. Crofton, could we do a Wednesday?
Yeah, but I've already closed it. You need to reopen it. Yeah, we can do that. It'll be April at 1:30. And if you could let them know, Ms. Dutch, so they're expecting him. And Mr. Crofton, you can go ahead and be taken back.
The judge denied the furlough motion without prejudice, meaning it can be refiled later. The defendant remains in custody with his confirmation hearing set for April 9, 2026. No day-for-day credit was granted, standard policy for this court, and the treatment bed date was forfeited. Pretrial release decisions aren't about punishment. They're about whether the defendant will return to court and protect community safety. Even when treatment is genuine, fresh misconduct and old warrants can keep doors locked. Subscribe for more real courtroom moments that show how justice actually works.